impact of coronavirus COVID-19 on businesses and individuals in the UK has been so enormous. Of late, we have noticed that some businesses have been impacted so much that they are considering what to do next in terms of their capacity to continue with the current number of employees. At the start of the lockdown, some employers had to put their employees on furlough. And we are now coming to the end of the furlough period, and some companies are now considering making their employees redundant. Some companies have also been offering their employees settlement agreements. In this episode, I'm going to comment on the process of how someone becomes redundant or how a company makes an employee redundant. Redundancy must be justified. In other words, the company must prove that it can no longer continue to accommodate all the employees that it has in its books, and that maybe it's now suffering from a financial impact that cannot be recovered from. So it is now important for its employees to be made redundant or to reduce the number of employees that it has. During the redundancy process, prior notice must be given to the employees. If the employee has worked for the company for less than 2 years, then a week's notice is required. Where the employee has worked for the company for more than 2 years, each year equates to 1 year notice that must be given to the employee. The employer must follow a process that is fair. It must not be discriminatory and must not target people based on their age, sexuality, race, beliefs, and or any other reason. It must be a fair process of selecting the person who can be put on redundancy. The employer must also be fair in the way that they calculate the amount of money that is going to be paid to the employee as a redundancy payout. If you require our services at Tanlaw Solicitors, will be able to assist you in making sure that you get a fair redundancy payout from your employers, as we have got qualified employment solicitors within the firm. Some companies are also offering their employees a settlement agreement. And as I have stated, under redundancy, that settlement agreement must be fair and must not be discriminatory. And in the process of being given a settlement agreement, most of the companies will want the employee to obtain independent legal advice from a solicitor or a qualified representative, with the company itself footing the bill for such advice to be given. And that bill is normally made, most companies that we have seen offer around £400 plus VAT to cover the costs. When you come to see us with a settlement agreement, we will go through the agreement that is proposed by the company. We will ask you relevant questions regarding your service that you have offered to the company. We will read through the agreement and paragraph by paragraph, and most of the agreements will have provisions on the service that you have done to the company, confidentiality, non-competing clauses, and how you can challenge the decision and things like that. So we will advise you on the impact of the settlement agreement that you are being offered, and we will then have to sign that we have given you independent advice and that we have got the appropriate public indemnity insurance that will cover us in the event of a claim from either the company or from yourself. Once we have signed that, then you can submit the settlement agreement to the company, and then the company can pay you out according to the settlement agreement. If you require advice from us, Tanlaw Solicitors, in terms for settlement agreements, we are here to help you. My name is Andrew Nyamayaro, a solicitor for Tanlaw Solicitors.